for his statement.
Thank you, Mr. Chair. Before we get into this subject, which is a serious and important subject, I want to recognize somebody who's here today. When I was a child, I was befriended by one of the great baseball players of all time, who justly should be in the Hall of Fame, Minnie Minoso. And his son, Charlie Rice Minoso, a friend, is here today, and I want to recognize him. Today's the last day of the baseball season, and a great baseball player's son is with us. Thank you, Charlie. A woman's constitutional right to choose to terminate a pre-viability pregnancy, which the Supreme Court established in Roe v. Wade in 1973, and which it has consistently reaffirmed, included as recently as last year, is a fundamental pillar of women's equality. The Roe decision was a watershed moment not only for the protection of women's right to choose, but for all Americans who believe that they should be free of unwarranted government interference in their most personal life decisions. H.R. 490 is a direct attack on that right. It is a sure sign of House Republicans' misplaced priorities and their failing agenda when they turn yet again to attacking women's right to choose. Just a few weeks ago, the House passed a blatantly unconstitutional bill that would ban abortions after 20 weeks of gestation. It will go nowhere in the Senate. All the arguments against that bill apply with equal or even greater force against this bill, H.R. 490. This bill bans all abortions where a fetal heartbeat is detectable, which means, as a practical matter, it would ban abortion after just 6 weeks of gestation. This is patently unconstitutional. Roe and the line of decisions following it have all made clear that prior to the point of a fetus's viability, a pregnant woman has an undeniable constitutional right to choose to terminate a pregnancy. Viability does not begin until around 24 weeks of gestation, not 6. Therefore, by banning pre-viability abortions after as early as this 6-week gestation, this bill would substantially narrow the window within which a woman may exercise her constitutional right to terminate a pregnancy, flies in the face of Roe's central holding, and in essence flies in the face of the Constitution and the laws of this country. In short, H.R. 490 can only be upheld as constitutional if Roe were overturned, which is clearly the ultimate intention of the bill's supporters. Probably they want something at the moment of conception. In addition to threatening women's equality and rights, H.R. 490 threatens women's health. The bill has no exception to its abortion ban for procedures needed to protect a woman's health, and has only limited exception to save a woman's life only when it is threatened by a physical condition. The American Congress of Obstetricians and Gynecologists say, quote, safe legal abortion is a necessary component of women's health care, unquote, and many health-related factors determine whether a woman chooses to terminate a pregnancy, including illness during pregnancy. The American Congress of Obstetricians and Gynecologists further notes the chilling effect that H.R. 490's criminal penalties would have on physicians, and express concern that, quote, physicians who act in the best interest of their patients by providing medically necessary care will face criminal sanctions, unquote. And I should mention here that I had received a statement today from the college concerning the testimony of Dr. Altman, and they say, while Dr. Altman is a member of the American College of Obstetricians and Gynecologists, a fellow, I believe, she has no official position with the college, and her appearance before the House Judiciary Subcommittee on the Constitution of Civil Justice is not on behalf of the organization. Her testimony does not represent ACOG's views or policies. ACOG submitted a statement for the record opposing H.R. 490. The bill violates the Constitution and is gross political interference in the practice of medicine, prohibiting physicians from providing legal necessary care to their patients. ACOG urges the House to reject this bill, as I believe do every other medical group who has taken a position on the bill, a legitimate large medical group. The lack of a health exception potentially places women's health at grave risk, and the life exception specifically does not include life-threatening psychological or emotional conditions, including suicidal thoughts, and does not even cover severe threats to a woman's health. Politicians are not doctors. Some may be, but most are not. And our jobs here is to be politicians, not doctors. And supporters of bills like H.R. 490 should stop trying to use politics to interfere in the practice of medicine. Finally, this bill has a lack of any exception for rape or incest, demonstrates a complete lack of sensitivity regarding these horrible crimes. According to the study of the American Journal of Obstetrics and Gynecology, more than 32,000 pregnancies result from rape each year, and rape-related pregnancies occur with significant frequency. Yet H.R. 490 would further victimize rape and incest victims by forcing them to carry such pregnancies to term. For these reasons, H.R. 490 is wrong on both constitutional and moral grounds. It undermines women's equality and their dignity as human beings. I strongly oppose the bill and would ask without objection to enter into the record written testimony and letters opposing this bill from the American Congress of Obstetricians and Gynecologists, a letter from the American Academy of Family Physicians, a letter from Planned Parenthood, and a letter signed by 29 faith-based organizations and civil reproductive right groups opposing this particular law, and it ranges from Methodists and Presbyterians and you name it. Written testimony of NARAL opposing it as well, without objection.
Hearing no objections, so ordered.
Yield back the balance of my time.
Chair thanks gentleman for his